Hello there. This is again Dean Joe-Santos Balagtas Bisquera coming into you now with the third version of our suggested answer on the private, personal, and commercial relations bar examination of 2022. I have already uploaded the suggested answers except that this Apple iMac of mine did not function by way of its audio. And so what you saw in the previous uploads were live presentation, but they were really soundless, And many of you who saw the suggested answers missed the excitement of hearing my voice and therefore sent me messages that Dean, we would prefer to hear you explain the answers. And so this is the commitment. The audio is already working and there have been earlier uploads just a while ago on the suggested answers on the law relating to the state, which covers political law, labor law, and taxation. You might, after watching this, you might want to take a look at that particular examination. That was the first examination on February 4 in the morning. Criminal law is coming up anytime now, and of course, the most exciting is procedural law, which covers, of course, criminal procedure, civil procedure, evidence, and special proceedings. But this one is equally interesting, obviously, because this covers the three subjects of what they call this the persons and family relations, more especially the family code, followed by, of course, the general provisions of the civil code on personal relations, including contracts, and finally the coverage of commercial law. And so, without much ado, we will let's take a look. This particular slide also contains an appreciation of the techniques in taking the bar examination, notably in the context of the word pass, P-A-S-S, but and presented in the reverse order. And so, without much ado, let's take a look at what we can share together. Let me just finish this particular thing. Just an emergency text as we try to go on to the first slide. Well, this one, many of you already know me, and therefore I would skip talking about the three major fields where I'm coming from. The field of my academic preparation, the field of 45 years in the corporate world, and now the field of law, which I started in 1994. And I guess I am very comfortable with having reached my childhood dream of becoming a lawyer. And so, without much ado, let's continue with this one. Yes, the three major areas, corporate management, and of course the field of law. And you will notice here I took pains in putting the logo of some of my most leading companies, Fuji Xerox, where I was executive vice president and senior and chief finance officer for 7 years. I started my career with ESO, which became Petron. I was there for 5 years. Motorola, I was finance manager, staying there for 13 long years. And GlaxoSmithKline, a pharmaceutical company, I stayed there for 5 years. So, continuing now, this is a beautiful feature that You have a curtain, and this is based on the latest MS Office 365. So just to run through the past the bar slides, just to give you some inspiration, especially for those of you who are still in law school and preparing for the bar. That pass the bar, it can be an acronym that spelled PASS, but in trying to master the technique of taking the bar, especially this computerized bar examination, you do the pass on the reverse order where you start with the last two S here and then A and then P. The first S, when you write your answer in the bar, is suggesting that you use simple words. Avoid using complicated words, except in my recommendation, the issue of whether or not the UN General Assembly resolutions would form part of the set of laws that a state can follow. I needed to introduce a very appropriate doctrine, the Facta Sunt Servanda, and that was whispered to me by the late Dean Celedonio Chongson, because he was my professor in that subject. In the area of simple words, that's one very good example, unless you're really bound to use Latin terms or something that's complicated. This is one example, which is an answer to one of the problems here in this subject. The answer is the corporate hospital is solidarily liable for the negligence of the physician. The word physician is already layman, but perhaps this will sound even more friendly. The corporate hospital is solidarily liable for the negligence of their doctor. Between physician and doctor, doctor seems to be a simpler and more familiar word. And if you use that in the bar examination, you have a stronger chance of being appreciated by the examiner. So use simple words when you give your answer. Second would be avoid using kilometric sentences and kilometric answers and paragraphs. Adopt, short sentences and rather than use compound complex sentences. When you have your sentence starts with an if, when, all of these things are premised on using compound complex sentences. Avoid them. Cut them into your answers, cut them into shorter sentences. And you will also have a tendency to condense your answer because your sentences are also small. It will be your tendency to really pass on whatever you want to communicate to them in short sentences. And then obviously, this is one example. It's in the problem on insurance. The life insurance beneficiaries will be entitled to the proceeds. The insurance had no concealment because he did not neglect to disclose his mental disorder that he did not know about. Take a look at how you can even make it shorter. The beneficiaries, and that's obvious they are the life insurance beneficiaries because that is precisely already the problem. You don't have to repeat yourself there. The examiner will understand. The beneficiaries can collect rather than will be entitled to the proceeds, can collect the insurance proceeds. The insured did not conceal about his mental disorder. See? So simple. And who will ever disagree with you if you are the one correct, if you are the examiner correcting the paper? You can never deduct anything here because it's already complete. And yes, it is straight and short. So you use your chances. Third is A. Well, this is actually the active mood. As you know, there are two ways of writing your sentence. One is the so-called passive mood, and the other one is the active mood. It is very simple to identify them. The passive mood, the typical sentence is subject predicate. And the active mood will always follow the active with the subject predicate structure. However, because we Filipinos, the structure of our Filipino or Tagalog has been influenced by Spanish as a language. Spanish is very courteous and therefore it normally avoids direct, the tone of being direct. Their popular mode of communicating is usted, kayo po. That's why in Tagalog, kayo po. O hindi ikaw, hindi kayo po. And that is exactly a passive mood. And that's good for communication, except when you're writing a bar answer where you need very direct answers so that it becomes easy to understand. So you use subject predicate rather than predicate subject. And so here is one example. The marriage was solemnized publicly by a duly authorized Supreme Court Justice. Notice that the actor is the duly authorized Supreme Court Justice, and it comes under after the word by, and so you can readily understand that this is a passive mood because the doer, the Supreme Court Justice, doesn't come in ahead. Let's take a look at if you were to recast this. A duly authorized Supreme Court Justice correctly solemnized the marriage in public. How can this particular straightforward active mood sentence be misunderstood compared to this what you call this very passive tone, very passive tone. Okay, and finally, of course, the word P. Well, the P is pass, but they will also stand for people. This has already been avoided by the Supreme Court. Probably, as a bar reviewer, I've always verbalized this in my bar review that if there is a name used in the problem for emotional and psychological reasons, make use of that problem because the chances are the examiner must be using a name that is too close to his heart. And when he corrects your paper, he probably will be a little more tolerant if he sees the names that he gave in the problem unintentionally that you're using. And so, his compassion drifts away in your favor or drifts towards your answer. And so therefore, you will have a more favorable chance of getting his sympathy. Now, having repeated that, the first chairman who heard probably about this is the 2019 chairman, Justice Perlas Bernabe. Because he did mention that in the meeting with the deans where he said he avoided using any names at all precisely to avoid any possible emotional impact on the on the correctors. And I noticed he did not use people in his in the 2019 problem. And definitely, I also did not see this in the Leonen set of questions. There has been intentional avoidance of using people. But if there is people, then psychologically you make use of them. Here is one example. Well, this is the same example as the one. I did not anymore prepare any illustrative thing there because that is something that is easy to understand. So again, pass, simple word, short sentences, active mood, people. Use that and see, as my critics, whether I follow that also in my suggested answers. My answers are really so brief that you will notice some of them are be one sentence or two sentences and much shorter than the problem itself. That's another technique I'd like to share with you. There are certain kilometric questions, and you will see in my presentation, you will have one half already of the screen covered with the words in the problem, and yet all of the details that were given there, probably even without reading it, you can you can understand, and you will know how to answer the question which is at the back, at the bottom. And so I would strongly suggest that when you read bar problems, you, especially when they look kilometric, you immediately go down to the last part, which asks the question. Because who knows, the question only is something that you can readily answer because it's a definition. What do you understand, for example, by discretionary duty or function, and then so that the long hypothesis immediately zero din. Sometimes the bar problem is intended to really confuse you. Like I saw some problems. Your tendency is, for example, to let your mind drift on the details of the paragraphs ahead of the question. And yet the question can be answered without even going into the details. So like the one question would be there was one I encountered that I don't immediately remember right now. But the key to answering the bar questions is immediately go to the last portion, the last paragraph, which is asking the question. And make sure you focus your style of questioning, you're answering to the question. Like, is he guilty or not guilty? Is he liable or not liable? No? Is his recommendation correct or not? And so immediately your premise is yes, no, I agree. Something like that, straight to the point. And probably you read only the details in the earlier paragraphs, if only to get some indications on why your answer to the bottom line will not be what you thought in mind initially. No, and so that's something that you need to also be so conscious about. Be very, very attentive and focused on the question being asked and answer that. And if you can answer that somehow with minimal focus on the paragraphs ahead of it, you'll probably be able to move very fast. And so without much ado, we continue to move on in our beautiful curtain there. And so this is the coverage of the combined subject on civil law and commercial law. So you'll have questions on persons, you'll have questions on private relationship, and you will have questions on commercial or business relations. Now, in the area of personal relations asked in this particular examination, the questions that were asked were, of course, expected questions on the family code and questions on quasi-delict. There were 4 questions on the family code, and very interesting, and only 1 question in quasi-delict. So that is in the area of personal relations. Now, in the area of private relations, there were only 2 subject matters. One, if I recall right, 2 questions on contracts and 2 questions on property. And considering that the subject matter of private relations is a wide area, including the types of contracts, types of obligations, what have you. Now, the third grouping would, of course, be the questions on business or commercial relations. And there were questions on corporation law. There was one question in insurance, and 1 question in intellectual properties. Okay. And you will notice in the area of insurance, what was asked is something I almost, I actually predicted, and I could have given that to you if my IMAC did not break down on me. But what I was referring to is suicide. It was asked. And in the area of intellectual property, we'll go into that. So without much ado, let us now go to the first grouping, which is personal relations. The question on personal relations. Initially, on the family code, there are 4 questions asked, and let's take a look at it. The first question on the family code has something to do with pre-nuptial agreement. And this is question number 1. So open the examination booklet. And the question is, a couple executes a pre-nuptial agreement which principally provides that their marriage shall be valid for only 5 years, but that it can be renewed through mutual consent, negotiated at least 6 months before its expiration. Is this contract valid? Explain. See, this is what I was referring to. Immediately go into the question being asked. is the contract valid? And so what is the contract being referred to? The Pre-Nuptial agreement. See, it is easier for you. So your answer will be focused on this. Is this contract valid? Your answer is yes or no, and the reason why the Pre-Nuptial agreement will not be valid. And the reason for that is because here, the provision of the Pre-Nuptial agreement makes the marriage valid only for 5 years. And you know that the family code does not provide for that. And there is a mutual negotiation to extend it beyond the 5-year period. Okay. So what is on the question of is this contract valid? Explain briefly. What is our suggested answer? The answer is no. The prenuptial agreement is not valid. So the answer is directly answering the question. The family code provides that marriage is a permanent union and not subject to stipulation except the property relations during the marriage. See, it follows it is what you call it uses simple words. It uses short sentences. Well, this one is a little long because of the word except and end. You could have broken down this one into 3 smaller sentences. But that would be okay. Once in a while, you give an exception. But notice the first sentence is direct to the point and very short. No, the prenuptial agreement is not valid. And if you were the examiner, says why? So you say, because the family code says that the marriage is permanent union. See? No, and not subject to stipulation. Okay. So that is question number 1, and that is the suggested answer. The second question on personal relations is question number 3, which again is one of the most expected questions, the reappearance of a missing spouse. So the question runs, a wife was able to validly claim a judicial declaration of her husband's presumptive death after he had disappeared for 10 years. She then remarried in accordance with law. To her surprise, a few years after her remarriage, her first husband reappeared. Thus, the first husband's reappearance automatically, without need of any further act, terminate the second marriage. Explain briefly. So here, it presupposes that the bar candidate already is aware of the specific highlights of the missing spouse. First, there are 3 periods involved here. 10 years is the period where the surviving spouse of the missing spouse may desire to not only get married but also divide the conjugal property or absolute community property. The partition can only be done in 10 years. So there are 2 things that the surviving spouse can do. One is remarry with the application for court declaration of presumptive death. And the second one is also the court sanction that the properties can already be partitioned so that the children and the surviving spouse will get their respective shares. Now, the second period is 4 years. And remember, what is imperative in this situation is that the surviving wife has already exerted all efforts and is convinced that the missing spouse is already dead. And that's the reason why she goes to court as part of the minimum requirement. She goes to court because the body, the corpus delicti is not there. The body of the missing spouse is not there. So she says to court, can you give me a decree that I can now presume that my missing spouse is already dead? And therefore, with your court decree, that will allow me to remarry based on the 10-year period and also to partition the properties. Now, on the other aspect of the period, rather than wait for 10 years, the surviving spouse can remarry on the fourth year. So after the husband is missing for 4 years, the surviving spouse, believing that he is already dead by his being missing, can go to court and ask for a court decree of presumptive death. The only difference between the situation when the surviving spouse was waiting for 10 years rather than 4 years is that in the 4 year period, she is not able to partition the property. She can only remarry after receiving the decree of presumptive death. No? So that our suggested answer would be referring to the reappearance. No? After she got married, nag-reappear. Oh, and the answer is automatic. Is the marriage to the second man or automatically severed? And the answer is no. The reappearance of the first husband uh, the reappearance of the first husband terminates the second marriage only after the recording of the affidavit of reappearance of the absent spouse. In effect, the system that will operate is that after the marriage to the second husband of the surviving spouse, and there is reappearance of the supposedly missing first spouse, there is not the second marriage is not automatically dissolved. It needs an operative act where the husband submits and records his affidavit of reappearance before the civil registry. And obviously, he is informing the wife, hey, I'm already here, you know. And so with that exercise, those are the premises say, hey, come back to me because I'm still alive. And so that dissolved the second marriage. And of course, the consequence is that the children out of the second marriage will continue to be legitimate because it is not their fault that the supposed missing presumed dead spouse reappeared. Okay. And so that is how this thing. There has to be the operative act of dissolving the second marriage happens when the missing husband would present an affidavit of reappearance and have it registered with the civil registry, of course with due notice to the surviving spouse and obviously also the second husband. Oy, tsugi ka na. That is the situation. That is what is being asked. But this triggers me to ask a very naughty question. And I have been asking this in our discussions about the family code. Here, the presumption is that the wife is so eager. That's why she's been looking for the missing husband. And the missing husband must have been so excited. I'm here, I got lost in the fighting in for example, in Marawi. And I happen to have been able to survive all the wounds and I'm here. And I'm taking you back and I expect you to take me back. Yan ang scenario. But let's go to another possible scenario. The husband, during the time that he was missing, 4 years or even 10 years, found another woman, a younger, more beautiful, more caring, more loving. But he knows that he's married, so he could not marry this girl. And so after he heard that the wife, surviving the wife, got married, he got so excited, because that means the wife must have already be, substituted all the emotions and all the care in favor of the second man. What if this husband is also in the same boat that he feels, well, I like this girl that I have been with for the past 4 years. She's younger, she's mas makarino, mas bata. And so I would rather stay with her, lalo na we have also children already. So what if he opts now not to prepare and submit the affidavit of reappearance. So factually, he's alive. But legally, because of the court decree on presumptive death, he is legally dead. So what happens now? What is the status of the marriage of the surviving wife with the second husband? It would seem to be legally valid and subsisting, even when, factually, the first husband was not missing. So officially also, you can also say that the second marriage is a bigamous marriage. Kaya nga exception, yung marriage na yun is under exceptional circumstances also dahil nga presumptive death. Pero kung ayaw nga yung nawawala he is not also interested in the reunion. So what happens now from a legal standpoint, there will be a question of whether or not the second marriage is dissolved. Now, the first complexity there would be in the property relationship. Kasi mawawalan siya yung kung mag-partition, let's say before 10 years, sa kanya pa yung kalahati ng conjugal property or absolute community. Would he be so happy to just give that away? Okay kung 10 million, siguro pwede pa niya sabihin 5 million, sige na sa inyo na. Malaking 5 million pero sige na, happy na ako. Pamigay ko na. What if you're talking about 100 million? This fellow will not come up front and say, teka muna. 100 million, 50 million sa akin yan. That would probably be one big house and lot, with some businesses and so on. Tapos magpapaligaya kayo na dahil nawala lang ako. So he will be caught in a dilemma where he will now reappear and declare that he is alive because of the property relationship, even if the emotions are no longer there. Ang problema, if the wife already got carried away with the second husband, and also in his case, he also wanted to continue with the relationship. You see how messy things can be. For example, namatay yung babae na sa kanya. Oo. Di ngayon magkakagulo ngayon yung hatian ng mga children, di ba, no? Oo. Of course, kung lahat sila legitimate, di equally. Pero will he not come forward and say, teka muna, buhay pa ako ngayon siya maglalabay ng affidavit of reappearance. Because he would like to claim now. Yan ang mga complexity. That's why this question was asked in the bar. But the subsequent consequences kung hindi mag-affidavit of desistance yung missing spouse, that will be a very interesting case. Sige, abangan nyo yung mga kukuha ng bar examination. Tingnan natin. Sana hindi ibigay. Kung ibigay, you better go into reasoning out. Okay? So continuing now, the third question on family relations has something to do with the solemnization of marriage. As you know, this is one of the fundamental requirements. Kung hindi walang public ceremony, the void yung marriage. So, problem number 4 in the bar exam is 2 college sweethearts were married inside a Roman Catholic church in the Philippines with a Supreme Court justice serving as solemnizing officer. A few years following the ceremony, one of the two filed an action for the declaration of nullity of marriage on the ground that the marriage was void ab initio because it was solemnized inside a Roman Catholic church by a Supreme Court justice and not by a Roman Catholic priest. Is the position legally tenable? Explain briefly. Again, focus on the question. Is the position that the marriage is void because ang nagkasal yung associate justice ng Supreme Court. Pero kinasal niya sa simbahan. Hindi sa kanyang chamber o hindi sa wherever he is supposed to be normally functioning. Kung simbahan, dapat Roman Catholic Church. Let us take a look at our suggested answer. No, the position is not legally tenable. The duly authorized Supreme Court Justice correctly solemnized the marriage in public. Kasi sinasabi lang naman, authorized yung solemnizing officer. Supreme Court Justice, kahit saan yan pwedeng magkasal. No? And also that the ceremony should be in public, hindi nakatago. Ginawa sa simbahan. O di public yun. Diba, no? So, ang question ngayon, bakit nakakagulo? Kasi normally pag kinakasal sa simbahan, dapat yung pari ang nag-officiate. Solemnizing officer din yun. Di lumakad na, dahan, nandun sa harapan, no? Tapos nakatayo na yung pare. Nagkataon yung Supreme Court Justice, uncle nung babae. Gusto ng babae siya, sabi nung Justice sa Supreme Court Justice, Father, tumabi-tabi ka nga dyan, ako magkakasal. Siya nagkasal ngayon. No? And so, of course, maaaring hindi niya ginamit yung libro ng pare. Simply say, do you accept, Maria? Do you accept Pedro? Pedro, do you accept Maria? And then, do you give yourself up to him as husband, as wife? Ganun lang. Oo. So, the answer is, well, hindi tenable na void ab initio because yung solemnizing officer, authorized, Chief Justice ng Supreme Court. At sinabi public, public naman yung simbahan. Wala naman sinasabi sa family code na yung dapat solemnizing officer na sa simbahan ginawa, dapat yung pare. And so the answer there is, the position that the marriage is void is not tenable. Okay? Next, the fifth question has something to do with the foreign divorce for Filipinas. And this is an expected question because there are at least 5 celebrated divorces that have been recognized before Philippine courts by the Supreme Court. Problem number 10. It reads, a Japanese national was able to obtain a divorce decree concerning his marriage with his Filipino wife. The decree capacitated the Japanese national to remarry. Can the Filipino wife now avail of Article 26 of the Family Code and then remarry? Explain briefly. Okay. Our proposed answer, yes, the Filipino wife whom the Japanese husband divorced can remarry after the Philippine court recognizes the foreign divorce. Straightforward question, answer, no? And it is already complete. The little notes here would only be clarificatory notes, and you don't need not write this because this will prolong your answer. But by way of an explanatory note, it says, where a marriage between a Filipino citizen and a foreigner is validly celebrated, and a divorce is thereafter validly obtained abroad by the alien spouse capacitating him or her to remarry, the Filipino spouse shall have capacity to marry under Philippine law. And this particular case, the most recent jurisprudence is Republic of the Philippines versus Marilyn Taniedo Manalo, a 2016 decision of the Supreme Court. So that is complete by itself. When you say, yes, the Filipino wife, the Japanese husband divorce can remarry after the Philippine court recognizes the foreign divorce. So the foreign divorce has to be presented before a Filipino court, and the Philippine court gives recognition to the foreign divorce. So it becomes a divorce that has become part of Philippine jurisprudence. Now, just by way of interaction here, there are 4, fifth including Manalo's case, 4 celebrated foreign divorce cases that have been recognized before Philippine courts. The most memorable here is the marriage of a Filipina to a German, and the Filipina's name is very sentimental, Imelda Pilapil. A combination of 2 ladies, Imelda Marcos and Pilar Pilapil, Imelda Pilapil. Well, this is covered by my lecture on conflict of laws, which is, I think, one of the most popular YouTube uploads that have had more than 10,000 viewers. And there we said that Imelda Pilapil married a German citizen. and they went to live in Germany. After a while, the German filed a divorce and was granted the same by a German court. And so the very sad Imelda Pilapil had to come back to Manila and has to survive as a divorced wife of the German. However, the German is a businessman that comes to Manila every now and then. And in one of his trips, somebody whispered to him, "Uy, you know, your wife Imelda is involved with another man, and you can sue her for bigamy because she is still your wife under Philippine law, and she's having a sexual relationship with a man other than her husband." So the German filed the case of adultery for the supposed wife not having intercourse with a man, not her husband. Well, the court decided against Imelda initially until her appeal reached the Supreme Court. And the Supreme Court effectively asked the German husband, in your German law, are you still the husband of Imelda Pilapil? Obviously, his answer is no more by reason of the divorce. Then the Philippine court said, if you are no longer the husband of Imelda Pilapil under your own law, why should we consider you also her husband under Philippine law? If you are not the husband under German law, then Philippine law should also consider you not her husband. And so that therefore, her sexual relationship with another man would not equate to her being a married woman having a relationship with another man, not her husband, because you are no longer her husband. And so in that particular case, the Philippine courts effectively recognize the German divorce as existing and valid before Philippine law. There is, of course, the provision for some of you who are who need to understand it more, that under the principle of conflict of laws, that when you are a Filipino, insofar as your personal circumstances and civil status are concerned, you follow the civil code provision which conforms with the nationality theory. So that in determining your civil status as a married person, that is governed by Philippine law. And since Philippine law does not recognize divorce, once you are married, then you are forever a married person. And so in that particular case, Imelda Pilapil, under normal conditions in Philippine law, is considered to be a married person. And when she has a sexual involvement with another man, not her husband, she is guilty of adultery. And so the decision that the husband is not anymore her husband under both German law and therefore Philippine law will now make Imelda, under the nationality theory, exception to nationality theory, no longer married, when normally she would be considered married forever. This is also true for the three Filipinas separately married to the Japanese, where it was the Japanese, who married each of these Filipinas, and subsequently each of these Japanese husbands filed and succeeded in securing a divorce decree from their Japanese courts. And so these three Filipinas, came back to the Philippines so lonely that they cannot even remarry because under Philippine law, once they married the Japanese, whether under Japanese law or Philippine law, under the principle that if it is valid there, it's valid here, then they continue to be married to the Japanese, even if each of the Japanese husbands have already remarried. And so that is when they went to the Supreme Court and said, Mr. Supreme Court, please be fair to us. If in the case of Imelda Pilapil, the German is no longer recognizing her as uh, recognizing him as the husband. Therefore, you should also follow the same principle that our Japanese husbands who do not recognize themselves as our husbands under Japanese law should also be treated that way under Philippine law. And so we should be an exception to the nationality theory. And the Supreme Court said, oo nga naman, in fairness and equity, kung ginawa na natin kay Melda yan, tapos sila naman kawawa, nag-asawa na yung mga Hapon na asawa, tapos sila hindi makapag-asawa dahil nga married pa under Philippine law, gawin na natin exception. Let the foreign divorce be presented before Philippine courts for the Philippine courts to determine that other than the restriction in the Philippines, those divorces are valid and subsisting. And so that therefore, hindi na rin married itong mga Filipina, pinag-asawa na. Ngayon, yung kaso ni Manalo, very interesting. Because in the three cases of the ladies who married the Japanese, it was the Japanese husband that triggered the divorce. Yung kay Manalo, si Manalo ang nag-file ng divorce before a Japanese court and she was granted. That's why when the trial court was looking into her situation, they said, Miss Manalo, your situation is not identical to the three Filipinas married to the Japanese. Because in their cases, kawawa sila because it was the Japanese husbands who filed the respective divorce. Sa'yo, ikaw ang nag-file eh. But when the Supreme Court finally got hold of the case, sabi ng Supreme Court, let us no longer make any distinction. Basta nagkaroon na ng foreign divorce yan, no? At nag-aasawa na yung foreigner, pwede na mag-asawa. Let us not anymore punish our Filipinas by considering them married only for purposes of following our nationality theory. Okay? So yan ang mga cases under the issue of marriage. No? Pero merong ikalima na ito parating pinag-aaralan nito by our, what we call this, by our law students. No? Eh dito ang tanong, will the suit prosper? So what suit? So let's go ahead. Problem number 11 in the bar examinations reads like this. And this is the fifth. No? Dami oh. 5 under the family code and marriage. No? It reads, a bride declined to appear on her wedding day. Instead, she sent a note to her prospective groom saying that she needed to be honest to herself by admitting that the institution of marriage was not for her. The bride wrote that she came to this conclusion after contemplating on the tweets of the Pound Love Guru. She also wrote that to atone for her non-appearance, she would post a glowing recommendation to this prospective groom as a partner on her Facebook, Twitter, Instagram, and TikTok accounts. The couple had previously dated for almost 8 years. The whole time, the prospective groom had been loyal and caring. It was the bride who covered all the wedding expenses. Heartbroken and embarrassed, the prospective groom sued the prospective bride for moral damages, alleging that she had breached her promise to marry him. Will the suit prosper? So it is the suit of the prostrated groom na the wife did not appear on during the scheduled wedding ceremony. Now, our suggested answer. No, the damage suit will not prosper. A mere breach of promise to marry is not an actionable wrong. The Civil Code has no provision authorizing an action for breach of promise to marry. That is a complete answer by itself. And so you can rest that if your answer is C, it is much shorter than the kilometric question. And many of the details, like in the first paragraph, were really irrelevant to answer the question that will the damage suit of the groom prosper when the prospective bride did not come? Yun lang ang question doon. And so you answered that. No, the damaged suit will not prosper. A mere breach of promise to marry is not an actionable wrong. The Civil Code has no provision authorizing an action for breach of promise to marry. Now, as a little colatilia for purposes of understanding the subject matter, the groom can take action against the bride for damages. And this was decided early on in 1964 in the case of Wasmer versus Beles. So doon hindi dumating si Beles. For damages had he spent for the wedding expenses. Walking out of marriage is contrary to good customs, subject to both moral and exemplary damages. So what happened here is that on the day of the wedding itself, Beles did not appear. So, but Wasmer spent for the wedding expenses, unlike in the problem where it was the woman that spent for the wedding expenses. And on the basis of the issue on what the bride did as being contrary, no, to good customs yung hindi darating, then the groom can sue for damages, and one of the damages is the recovery of the wedding expenses plus probably some yun, exemplary damages because it is in violation of good customs, no. But this is a 1964 decision and the facts are not identical. So, but that can be a good point for you to remember. Okay? So that completes our five numbers of questions on personal relations coming from the family code. Now, the next question is a single question arising also from personal relations involving this time a strained relations with a person without any contractual obligation. So this is a quasi-delict. Let's take a look. The problem reads, a 12-year-old 7th grade student living in the company of his parents brought a gun owned by the father to school. With it, the student shot a classmate who had been a bully. The student missed sparing the bully. The bully's parents, incensed by the event, sued the parents of the 12-year-old 7th grade student for damages. The defendant parents moved to dismiss the suit, claiming that they could never be held liable for damages since they did not shoot the bully themselves. Should the motion to dismiss be granted on this ground? Explain briefly. Eh bakit kami iahablan nyo? Eh yung anak naman namin ang nambaril, hindi kami. Oh, yun ang katwiran ng parents, no? And so, our suggested answer, no, the motion to dismiss should not be granted. The father, and in the case of his death or incapacity the mother, are responsible for the damages caused by the minor children who live in their company. Two qualifications, minor and then living with them. The obligation imposed by Article 2176 is demandable not only for one's acts or omissions, but also for those of persons for whom one is responsible. And the citation, which is Article 2180, in relation to 2176 is, whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Such fault or negligence, if there is no pre-existing contractual relation between the parties, is called a quasi-delict and governed by the provisions of the Civil Code. Okay? So, yung mga ano yan, yung mga magulang na may bata na nanakit, eh pagka under sa inyo yung bata at minor, ibig sabihin minor living with you, then you will become equally liable for damages. Moving now to the second part of the subject. This is now private relations, and there are two sources of the bar problems in this subject matter: the contract and property. So let's move now to the problem on contract. The first problem in contract is problem number 6 on fortuitous event. It reads, A 100-year-old tree inside a university was uprooted by strong winds caused by a super typhoon. This was despite the university's prior efforts to maintain the strength of the tree's roots. The tree was blown away until it hit a nearby fast food restaurant where a bar candidate was reviewing for the bar examinations. The bar candidate, who was then the only person dining inside the fast food restaurant, suffered physical injuries. The super typhoon was enabled by climate change. Can the university be held liable for the physical injuries suffered by the bar candidate? Explain briefly. So again, you focus on the question. Can the university be held liable for the physical injuries of that particular student or bar reviewee on the basis of the flood? Our explanation. No, the university cannot be held liable because the injuries were caused by the typhoon, a fortuitous event. Tama na yun. Diretso. The university cannot be held liable. Kasi yung typhoon ang nakakos noon, which is fortuitous event. And the explanatory legal note, again, marginal note ito. Except in cases expressly specified by the law or when it is otherwise declared by stipulation or when the nature of the obligation requires the assumption of risk, ito lang pwede na i-cite. No person shall be responsible for those events which could not be foreseen or which though foreseen were inevitable. Yan ang sagot. Okay. So that is problem number 1 in business relations. On contracts. Number 2, this is the issue of consent and meeting of the minds. This one is this is essentially a highly arguable problem. The problem reads, your significant other shows you a laptop screen on which a mandatory question for the installation of an app appears. The question reads, do you agree to the terms and conditions of use? There are 2 buttons indicating alternative responses. One is labeled agree, the other is labeled disagree. The terms and conditions of use are not shown on the screen. Neither is there a hyperlink that can be clicked and that would reveal the terms and conditions of use of the app being installed. Curious why the terms and conditions of use are not available, you search the internet and come across media articles revealing that the terms and conditions of use allow the app provider to access a user's contact list, emails, and browsing history. These pieces of information are sold to advertisers who in turn tailor their emails to users so that they can engage in targeted advertising based on the user's profiles. Knowing that you are taking the pound best bar ever 2020_21, your significant other asks you this legal question. By clicking on agree, will there be a meeting of the minds between the user and the app provider, enabling access to the user's contact list, emails, and browsing history? Explain briefly. There are a number of gray areas here being explored, but let us try what our answer is all about. The recommended answer is contracts are perfected by mere consent when there is meeting of minds in the offer and the acceptance upon the thing and the cause. Continuing, yes, by clicking agree, there is meeting of minds that includes access to the user's contact list, emails, and browsing history. Said terms and conditions in media articles become an integral part of the app's offering, to which a subscriber may agree to express his consent in the installation screen. This is supported by the case of Swedish match AB versus Court of Appeal citing Gomez versus CA, a decision that was made in 2004. Continuing now, the second question has something to do with wrong delivery in a contract, apparently contract of sale. Problem: a seller posted an online advertisement for a 4-volume set of Tolentino's commentaries and jurisprudence on the Civil Code of the Philippines. 100 pesos only. A bar candidate excitedly ordered it and paid through GCash. However, when the set was delivered, tears started to well in the bar candidate's eyes. Much to the bar candidate's bewilderment, the author was not Arturo Tolentino, the legal luminary, as the candidate was made to expect, but Lorna Tolentino, the noted actor, hindi dapat actress, appearing in Provinciano as Lily. Continuing, the bar candidate believes that the contract of sale should be rescinded and that damages are also proper. Is the bar candidate's position legally sound? Explain briefly. My suggested answer: no, the bar candidate's legal position is not to rescind the contract of sale. The proper remedy is for him to ask the court to direct the seller to make the correct delivery per contract with damages. No? Lalo na rito, merong relevance yung tinatawag natin na exhaustion of administrative remedies. So kung mali yung diniliver, part of the remedy is tawagan mo yun. No? Sulatan mo, email mo na palitan kasi mali yung diniliver sa'yo. And assuming you were able to do that, ayaw pa rin gawin, then that is the time you go to court for a rescission of contract with damages. When the seller has broken a contract to deliver specific or ascertained goods, a court may, on the application of the buyer, direct that the contract shall be performed specifically without giving the seller the option of retaining the goods on payment of damages. If a person obliged to do something fails to do it, the same shall be executed at his cost. This same rule shall be observed if he does it in contravention of the tenor's obligation. Furthermore, it may be decreed that what has been poorly done be undone, the debtor fails to perform an obligation to do. Okay, so that's supposed to be the two problems in contracts. The third one has something to do with the Data Privacy Act. And here, it mentions sensitive personal information. And it reads, a university refused an award-winning journalist's request for a copy of a senatorial candidate's transcript of grades on the ground that it would violate Republic Act 10173 or the Data Privacy Act of 2012. The journalist, however, argued that the candidate's whole life should be subject to scrutiny by the voting public. Is the university's position legally tenable? Explain your answer. The suggested official answer looks like this. Yes, the university's position is legally tenable. The grades of a senatorial candidate enjoys privacy as sensitive personal information about his education, which cannot be the grades of a senatorial candidate enjoys privacy as sensitive personal information about his education, which cannot be collected or processed without the candidate's consent as prescribed under the Data Privacy Law of 2012. Okay, so those were the three problems given in the bar examination on contracts. Now we're ready to go to the problem on property. There are two problems in property, and the first one is a reasonable question. The question reads: four siblings co-own a 2-hectare commercially viable property located next to a major road. The siblings have equal shares, but none of them have exerted any effort to partition the property. A large retail conglomerate then offered to purchase the entire property. Three of the siblings were willing to sell, but one refused, wanting to hold on to the land in memory of their departed parents. The three willing siblings proceeded to sell their respective shares in the property to the large retail conglomerate. After the sale, the conglomerate filed a case in court to partition the property. Should the court allow the partition? I'll explain briefly. Our suggested answer is yes. The court shall allow the partition. The retail conglomerate is co-owner representing three parts of the property interest he purchased. He is entitled to partition, so he has full ownership, use, and control of the property interest he purchased. No owner shall be obliged to remain in the co-ownership rather. Each co-owner may demand at any time the partition of the thing owned in common, insofar as his share is concerned. Okay, so that is the first question on property, and that is on partition. The second one is an interesting hypothesis in civil law, and that is property the builder in good faith. The problem reads: believing that a parcel of land was public land, a farmer built a 2-story concrete house on it. 5 years later, a person showed up bearing an original certificate of title over the lot, which had been registered for more than 10 years. The person asked the farmer to vacate the parcel of land. The farmer refused to vacate unless the titled owner pays the fair market value of the house built on the parcel of land. Does the farmer have legal ground to demand payment for the house before vacating the parcel of land? Explain briefly. Now, our suggested answer is yes, the farmer has the legal ground to demand payment for the house he built. He is a builder in good faith because he had no knowledge of the land on which he built his house as a registered owner. He shall receive the necessary expenses as a refund for the repair of his house. The owner of the land on which anything has been built, sown, or planted in good faith shall have the right to appropriation. Okay? Nahanap ko yung pangalan. To appropriation as his own the works, sowing, or planting after payment of the indemnity provided for in Articles 546 and 548, or to oblige the one who built or planted to pay the price of the land and the one who sowed the proper rent. However, the builder or planter cannot be obliged to buy the land if its value is considerably more than that of the building owner. In such case, he shall pay reasonable rent if the owner of the land does not choose to appropriate the land or trees after proper indemnity. The parties shall agree upon the terms of the lease, and in case of disagreement, the court shall fix the terms thereof. That is in accordance with Article 448 of the Civil Code. So that ends our two problems in property. And so that therefore we move on to the third grouping under our personal, private, and commercial relations subject. So this is really moving towards mercantile law or commercial law. And there were three subject matters taken up under commercial law. The first one is the corporation. And the required answer here is under the revised corporation code. It is one of the most interesting subject matter, culpa contractual by a hospital, and it is San Juan de Dios that was involved in this case. The problem reads, a corporation which owns a hospital was sued along with the physician for medical malpractice. The corporation moved to dismiss the case, arguing that it was only the physician as the natural person who could be the subject of any kind of suit. In other words, the corporation argued that it was not a legal person. Is the position of the corporation that it is not liable, owning the hospital legally tenable? Explain briefly. Okay. Our suggested answer, no. The corporate hospital owner's position is not legally tenable. The corporate hospital is solidarily liable for the negligence of the physician. When the hospital holds itself as a provider of complete medical care, and said hospital impliedly created the appearance of authority for the physician to act in said hospital's behalf by virtue of the doctrine of apparent authority. The corporate hospital is also solidarily liable with the patient when the patient relied on the hospital to provide him with medical care rather than simply a place to find his physician and who thinks better. So that is the issue on what is called corporation law that becomes liable with the doctors on a solidary basis for some mistakes committed. This time we move to the subject matter of corporation. Reading now, and this is under the revised corporation code as amended, a one-man corporation. The paragraph, problem number 16, the bar reads, a single parent started a plant-based vegan meal delivery service during the COVID-19 pandemic using only the resources available in the kitchen and in a nearby market. After just 6 months, after just 6 months, the single parent needed to expand by hiring cooks, kitchen staff, and finance and administrative personnel. A bank told the single parent that it was ready to fund the small business, but that the parent needed to be registered with the proper government regulatory agencies. Friends advised the single parent that registering as a single proprietorship would make their personal assets vulnerable in case the business takes a downturn. The single parent now comes to you for legal advice, wanting to have the limited liability of a corporation, but is unwilling to take in partners in the business that would stifle their culinary creativity. Under the revised corporation code, is it legally possible for the single parent to register as a corporation with only the single parent as a stockholder? Explain briefly. Take note, without even going into the details of the so much explanation here, that last paragraph can be answerable by yes or no based on the revised corporation code. And the suggested answer, yes, a corporation may be organized with a single stockholder who is a natural person, trust, or an estate. And that's exactly what Section 116 of the amended revised corporation code says. The answer is so straightforward and so simple. The other question would be this time on the directors. And problem number 17 says on corporation, 2 years since it began to operate, a corporation has amassed assets valued at over 60 million pesos. It also has 250 shareholders, each holding at least 150 shares. Yeah. Under the corporation code, is the corporation required to have an independent director? Explain briefly. This one is a very straightforward answer. The answer is the corporation shall have an independent director constituting at least 20% of such board because its assets are at least 50 million pesos and have 200 or more holders of shares, each holding at least 100 shares of a class of its equity shares. Very straightforward answer. A question on corporation. So there are already three questions on corporation. And this will be the fourth and last question on corporations. And it reads now. A white hat hacker, a software engineer, a gamer, an ophthalmologist, and a computer engineer got together sometime in 2019 to develop a software that can identify a person using a photo of their eyes taken by a 10 megapixel camera. By early January, they decided that they needed more equipment and capital and that they had to protect their intellectual property rights. A wealthy entrepreneur offered to give them the funds they needed. They negotiated that the funds would be treated as investment rather than debt liability. Thus, the entrepreneur would recover through dividends rather than through amortized payments. At the same time, they did not want the wealthy entrepreneur to be involved with creative decisions in their business projects. To accommodate their desired arrangements, a new corporation was registered with the Securities and Exchange Commission. In this corporation, the wealthy entrepreneur held preferred non-voting shares while the others held common voting shares. By the middle of 2020, it became clear that the software was going to be highly profitable. Unlike other facial recognition software, theirs would be able to identify a person even with low resolution cameras found in most smartphones. It could also identify persons even if they wore face masks. Mindful of its profitability, a Chinese corporation offered to buy all of the assets of the corporation for $10 billion. Everyone wanted to close the deal except the wealthy entrepreneur who insisted that they should not sell all corporate assets but instead enter into software licensing arrangement as this would be more profitable. Under the revised corporation code, are the white hat hacker, software engineer, gamer, ophthalmologist, and computer engineer required to allow the wealthy entrepreneur who holds preferred shares to vote on whether they can sell all of the corporate assets? Explain briefly. Now, our suggested answer is no, only common shares can vote on acts of ownership to sell all of the corporate assets. And that is based on the decision of Roy versus PLDT, a 2016 decision. However, there is a little footnote here that I'd like to share. Controlling interest in a public utility can be achieved by applying the 60-40 rule to all classes of shares. The only way by which Filipinos can be assured of having the controlling interest is to apply the 60-40 rule to each class of shares regardless of restrictions or privileges present, with each class being considered as a distinct but indispensable and integral part of the entire capital of a public utility for the purpose of determining the nationality restrictions under the Constitution. The PLDT case was a very complicated case, but the general principle involved usually is if it is an issue of selling all of the assets of the corporation, and while it is recognized that the common shareholders would have the exclusive authority to vote on critical issues, there are 10 situations where even non-voting shares are allowed to vote, and these are corporate acts of ownership. And one of them is that all the shares will be allowed to vote when when the subject matter of corporate decision is to sell all of the assets, which is in this case. So under that hypothesis, even the preferred shareholders who were originally non-voting would be allowed to vote. And here we know that the dissenting opinion is coming from the preferred shareholder. So that's one second school of thought. The first school of thought is here only the common shareholders are allowed to vote. The second is include the voting in the voting the preferred shareholders, because the issue is the total sale of the entire what they call these assets of the corporation. The third one, which is being exposed under the Roy versus PLDT case, and this was actually covered by no less than Antonio Carpio before he retired from the Supreme Court. The opinion is, he looked at all the classes of shares, and if there is an issue involving the nationalization of certain industries, and in this case, it's telecommunications, which is part of the fundamental infrastructure, then the 60% participation should be applied to all kinds of shares and not only to the so-called common shares that would enjoy 60%. My personal opinion on this one would still be that the preferred answer would still be only common shares will vote for the sale of the corporate assets. Because here, the preferred shareholder originally was intending to only become a creditor and not a stockholder. It is not the act of ownership that he is involved in. So that essentially are the four problems in corporation law. We are about to move into the last two problems in the bar examination on the subject. Let's go to insurance. In the case of the problem on insurance, it reads, and this is involving suicide. 25 months after a life insurance policy had been issued, the insured committed suicide. Upon investigation, the insurance company discovered that the insured had been living with an undiagnosed major depression disorder for the past year before the suicide. Under the Diagnostic and Statistical Manual of Mental Disorders, 5th edition, DSM-5, a guidebook used by many professionals to diagnose various mental health conditions, major depressive disorder is recognized as a mental disorder. Would the beneficiaries of the insured's life insurance policy still be entitled to receive its proceeds? Explain briefly. This question is answerable only by yes or no as to whether the beneficiaries of the life insurance policy will be entitled if the insured committed suicide. Our suggested answer. Yes, the life insurance beneficiaries will be entitled to the proceeds. The insured had no concealment because he did not neglect to disclose his mental disorder, which he did not know. In addition, the suicide happened 25 months after the policy was issued, hence after the 2-year contestable period. The insurance company can no longer rescind the contract for concealment. So this was decided in the case of Manila Bankers Life versus Abat. So that's the only question that was asked on insurance, and so that therefore we're ready to move to intellectual properties, which was the last question on this particular bar problem. It was problem number 14, and it had something to do with copyright. A professor teaching intellectual property law distributed photocopies taken from a book written by another expert to a class of 15 law students. Excerpts shown in the photocopies were meant to be for discussion and criticism in one of the class sessions. Question: is this a violation of the law on copyright? The suggested answer: no, the photocopies of a book by another author for class discussion does not violate the copyright law. No violation on the inclusion of a publication made as illustration for teaching purposes compatible with fair use when the source and the name of the author, if appearing in the work, are mentioned. This is under Section 184 of the limitations of the copyright law. My dear friends, this essentially is the end of the three major subject matters under personal, private, and commercial relationships. And so we are ready to close our sharing with you on our suggested answers on the 18 questions that were given in personal, private, and commercial relations in the bar examination. The subject matters originally were persons, and then would involve, of course, all the provisions of the Civil Code on obligations and contracts and special relations. And finally, the question on commercial law, which included transportation where there was no problem, on banking where there is no problem, on corporation where we have about 4 or 5 problems, and then on insurance and intellectual property. So with this, ladies and gentlemen, I'd like to thank you very much for allowing me to rerun this presentation, which has already a non-talking, it was talking but no sound version of the solutions to this problem. The solutions have not changed. But what many of you are awaiting is for me, properly dressed like this, to be talking to you directly, because I was able to hurdle my technology problem with my iMac. And so I'd like to thank you very much for listening to me, and be comfortable to email me if there is any question that you have in relation to this particular suggested answers to the bar problems. I still owe you 2 subjects. The procedural law, which is, of course, the combination of remedial law, where you have your civil procedure, criminal procedure, evidence, and, of course, special civil action, special proceedings. And then, of course, legal ethics. That's one thing where I'm almost done with that one, and that will be uploaded soon. And second, I owe you the most interesting among us with the criminal mind, criminal law. And I also have very interesting perspectives, including some divergence of solution with others who have been able to earlier upload their solutions. And so with this, I'd like to thank you. Marami pong salamat sa inyong pagtsatsaga. And please do not forget, whenever you watch the YouTube uploads, meron po dun sa baba, no, sa inyong pinapanood doon sa kanan, sa baba, na isang buton. And that is what will allow you to subscribe to me. By just clicking that, then you give me a little bonus from what we call this from Google, which accumulates the number of readers. I've been in this ball game for 1 year now, and about 4 or 5 of my uploads have reached a readership of 10,000. And considering those who took the bar examination is 11,000, then while I am aware that many law students are watching this, we can further increase your patronage, and I will continue to be inspired by your following. And so marami pong salamat. Mahal na mahal ko po kayo for allowing me this little privilege of sharing with you a subject matter that I love so much, that I pushed myself into very dangerous situations to finally become Attorney Joe-Santos Balagtas Bisquera, today with Eliter Buloloy, Dean, College of Law, University of Manila. Marami pong salamat. I'll see you in the next slides. Thank you.